Say hi. Eric is here.
Good morning, everyone. Tom Heinrich here with Rep. Bellotti. Also, Hector Venegas will be joining on behalf of Representative, and she'll join as soon as she gets out of a meeting here in the office.
Great, thank you, Tom. Can you spell Hector's name? V-I-N?
Venegas.
Okay. Cool, thank you so
Thank
much.
you.
Okay.
Before we start, I just need to know, Eric Ave, are you wearing a Snuggie? I can't hear you.
I hear you.
You're on
but-
mute.
Yes, I am. The air conditioning in our office is like cranked up to the max and we can't change it. So it's like in the 60s in my office. It's freezing. So
I understand. My mother like has stock on Snuggies. That's why I know what that is. Like, cause she's like, I can't tell you how many Snuggies we have in this house, but from now on, Eric, you are forever going to be Snuggie. That's your new name.
okay.
Well, and it's appropriate. You got the northern lights or whatever
Yep.
Moving
Oh,
behind you there,
What's up,
Eric.
Snuggie?
Yep, that it's all appropriate.
You're a man after my own heart. I wear full-on blankets most days in the office. The AC is not great today, but usually it's like 67, 65.
But if you know Eric, like Snuggie it's perfect. It's a perfect, like I'm calling you Snuggie forever,
Mhm.
Eric.
All right, well, we are now at time. And so with that, we can start welcoming everyone. My name is Laura Reichar. I am the director of the Hawaii State Center for Nursing and will be calling to order the third of our meetings. And let me share quickly that I will be sharing things. For some reason, let me share a different way. Of course, everything is updated over the weekend, and so the my Google Calendar or my Google Sheets and Zoom is different today than it was on Friday as it happens. So please bear with us as technology always changes. So I will be sharing our agenda real quickly. I want to just reference to everyone, we accidentally sent out meeting 4 agendas in the agenda 3 sheet, and then we updated that over the weekend. Thank you to our RICO colleagues for catching that. And we are happy to have RICO and Board of Nursing with us today. So in just a moment, we will go through and do the welcome and introductions, and then we'll move through with our agenda. Speaking to the agenda quickly, we will review and approve the minutes. We'll do a quick administrative update. I will present briefly on the state's nursing workforce, on the license counts, and also updating and interpreting some information that NCSBN had provided. And then we'll give the time over to the Board of Nursing and RICO for the presentation. Does anybody have any questions about this agenda? Okay, hearing none, I will move on and I will do a roll call. So moving down our agenda, Laura Reichart, myself is present. Today we have Director Nadine Ondo. It's nice to see you here. Thank you for joining us. And Director Ondo is from the Department of Commerce and Consumer Affairs. For RICO, we have Rena Chung and Esther Brown.
Present.
Wonderful. Thank you both. Then we have Leanne Tashima and Chelsea Fukunaga from the Board of Nursing.
Present.
Thank you. Thank you both. And then Senator Keohokalole or Representative. And then Senator San Buenaventura or representative, and I see we have Anna.
Hi, Senator San Buenaventura is going to be about 15 to 20 minutes late, but she'll be here today.
Okay, wonderful. Thank you so much for that update. And then do we have Amelia Castro as well with us today, Anna?
No, it's just me.
Okay, great, perfect.
Thank you.
And then for our representatives, Representative Della Albalati will be coming a little bit late, and we have Tom Heinrich and Hector Venegas. Thank you for being here. Do we have Rep Nakashima? Or Lori Hasegawa? Lori, okay. For HAH, I see that we have Paige with us. Morning, Paige.
I'm present. Hi, Laura.
Paige and baby.
Yeah, sorry, he'll say hi. Sorry.
Hi,
Hello.
baby. Hi, baby. We welcome all members. This is a public meeting, Paige.
Thank you. Thank you. He'll be welcome.
Representing the Hawaii Health Plans, we have Walden Au on behalf of HMSA. Oh, sorry, and I skipped. Thank you, Walden. And then representing HGEA, we have Jesse Sleva. Thank you, Jesse. And then representing Hawaii American Nursing Association, we have Linda Beechner, who's in the room with us. And then I see a couple other people. So just for the record, we have Malia from HHSC, Malia Espinda. Good morning, Malia.
Morning.
We have John. Is this John? I'm not being able to pronounce your last name, but I can see it written. Is this John?
Garibaldi with Queens.
Thank you, Garibaldi. And then A.M. Nagamine.
And Nagamini from HHSC.
Ah, yes, thank you.
Thank you.
And then we have Chris Clark from Queens. Morning, Chris. And Brett Cole from Hawaii Care Choices. And I think that is it for the moment. Wonderful. Okay, first on our agenda, I wanted to share with you a quick update, and let me share my screen. So I wanted to share with you all that we have put up our nurse license compact study onto the Center for Nursing website. So quickly, if you go to the Hawaii State Center for Nursing, and then on the policy tab, it is the first sub tab, nurse license compact. Yeah, under here. Oh, and of course, I clicked on the wrong link. A little bit slow today. So under here, you can see the Senate concurrent resolution, the Nurse License Compact and Model Act, the link to the website, our working group schedule, the YouTube recordings to our meetings, which if we go to them, you'll see that we have a whole playlist that you can refer people to if they're interested in the meetings and what was discussed to date. And then we will be posting our supplemental materials, which go to a Google Drive, shared drive. If your organization does not have access to Google Drive, and we know many healthcare organizations do not, this is public information, so you're able to get it from someone else, and certainly you're always able to get it to us, so we will email you if you request that information. We'll email you the full list of contents. So that's just a quick information. We also wanted to share, and I'll go back to the agenda, that NCFBN did provide follow-up responses to questions that we had after their meeting, after the second meeting. And so please do take time to review this information, as it will all be considered as part of the working group study. I do want to also recognize that they did call out certain states. So as it related to labor laws, and as it related to let's see, commissioner administrator language, so enabling and conforming language, they provided other state examples, and I think that's a good resource, and I do encourage you to look into that information. And then, does anybody have any other questions related to the information on our webpage and the additional information that NCSBN provided? Wonderful. I will then move on to the next agenda item. So we actually have one presentation that I will start with, and then my colleagues at the Board of Nursing will continue with. And so there is first information that will clarify NCSBN's financial statement, just because that was, I think, a bit confusing to people. I had a lot of remarks after the meeting and actually during the meeting that there was a need for clarification. So we'll take a little bit of time to clarify, and then we'll move into the meatier part of the agenda with Board of Nursing and then Rico.
Hey, Laura, it's Leanne. Did you approve the minutes, or were you going to approve the minutes?
You know what? I just skipped past it because I was looking at the links. So thank you for asking about that. Let's go and do that. Thank you so much, Leanne. At this time, does anybody have any comments of related to the minutes, or do we have a motion to approve?
I'll motion to approve. This is Paige.
Thank you, Paige. Any seconds? I'll second. Linda, thank you. Thank you, Linda. Thank you, Leanne, as well for that reminder. Okay. Yes. Oh, do we need, and can we have a consensus vote for approval? Okay, hearing none, we'll take that as a consensus vote. For the minutes. Thank you so much. So I wanted to have a brief conversation about the nurse license counts. Let me go back because that was the wrong slide. Google is just killing me today, y'all. They are moving everything around. So I wanted to have a brief conversation, and the reason I wanted to have this brief conversation about the license counts and NCSBN's projections is that NCSBN provided financial statements. They did not provide total license counts. And so thankfully, DCCA, Board of Nursing provided those numbers to us last week. And those numbers have a bigger picture than, they provide a bigger picture than just that financial perspective. And so with that, here we go. In total for Hawaii, as of July 24th, 2023, the Board of Nursing reported last month or last week at the Board of Nursing meeting, and then also in individual communication, that we have 1,268 LPNs who are residents of Hawaii, and then an additional 390 who are out-of-state residents, totaling 1,658 LPNs licensed in Hawaii. And then for registered nursing, there's 15,200 Hawaii residents, 12,630 out-of-state residents, totaling 27,830 licensees who are registered nurses. And then you can see those totals on the far right column. So holding this number in your mind, or holding these numbers in your mind. One, the NCSBN communicated that there were approximately 6,975 licensees who lived out of state who already had a multi-state license compact for their residential state, their primary state of residence, PSOR. And so using that number, you can see that based off the fees for nurses, you can see this financial breakdown. I do want to note that it appears that NCSBN used the Center for Nursing Fees prior to the Act 66, Session Laws Hawaii 2022, which increased the fees to $60 every other year instead of $40 every other year. So there's a slight change to the overall amount. So it's $196 in total instead of $176 total. And this $6,975 is smaller than all out-of-state nurses. It's only related to the nurses who already have a multi-state license in their primary state of residence. So you can see that here. So that's as compared to this information. So they had this, the total license number. It was based off 176, and we provided that for their clarification. I also want to talk about the difference between projected fiscal impact and the projected workforce impact, because these are two different things and they cannot be conflated. And it's important that this working group understands that they cannot be conflated, because it's easy to do so, and it's just very important to make distinct categorization. So if we look at the decrease in license revenue for people who already have a multi-state license, that does not mean they will be there. It does not mean they will be less available to Hawaii, because the license type would change, but they would still have a license that would be recognized in Hawaii. So this 6,000, almost 7,000 nurses, between RNs and LPNs in total, they would still be accessible to nursing if they would change to a multi-state license and Hawaii recognize the multi-state license. So this does not impact the availability of a nursing workforce. It only impacts the revenue earned by Hawaii. And then in terms of potential revenue gains, a Hawaii resident with a Hawaii license and a license in at least one other state that is part of the nurse license compact doesn't change, again, the availability of this nurse because they're already in Hawaii. And so it might increase fees, but it doesn't make more hands on patients. It is just a revenue change. It is not a workforce change. And then that third category, Hawaii residents without a Hawaii license and a single state license in one or more nurse license compact state. There's a lot of unknowns about this category. This final one here where my cursor is, there's a lot of unknowns. So they could have, at the point in time that this data was collected, they could have had an active application in the Board of Nursing that just had not yet been reviewed. They could be part of the DoD and working on their primary residence under their license in their primary residence that is not Hawaii. Or they could have, they could be working telehealth and not ever having an intention to work in Hawaii because they are already employed and practicing in those states or that other state that they're licensed in. So there's a lot of unknowns. So there's not really any guarantee that these people who are living in Hawaii that have a degree in nursing might then become licensed and join the workforce. And so you can't really, I don't know if you could hang your hat and say, oh, we might be able to get 1,000 more nurses from that category alone. So I described that a little bit here. So if you want to explore this further, I have more of a description of why revenue does not change workforce. I think it's important to note that we would have revenue changes, but the workforce changes may not be that significant because the greatest change would be in revenue would be the loss of revenue from people who live out of state and already have a multi-state license compact, And actually, we have a much larger proportion of people who live out of state and continue to be licensed in Hawaii. And so that workforce has already shown that they're willing to come into Hawaii one way or the other. And so it would I just want to separate the two pieces of information. Does anybody have questions on that?
Hey, Laura, this is Paige. One of the questions I would have, can you go back to the previous slide? So a little bit more forward. There we go. So I think, one of the things that I had noticed with the NCSBN presentation was that the potential revenue gains, I think, potentially looked a little smaller. And I think it's important to note that that third category, that second category under the potential revenue gains, it is kind of this funny, like, well, yeah, who exactly are these folks, right? And where are we counting them? I think that's a really, really astute point. But I guess one of the questions, when I had looked at it, I thought, well, gosh, it's a potential revenue gain of only about 86,000. But based on your previous slide, it looks like there's about 30,000 people who have licenses in the state between LPN and RN. And so I just, did a quick calculation that, if there was an add-on fee of $100, even if you only had 50% of people elect to get a multi-state license, right? That would quite easily cover, I think, some of the lost revenue. So just to focus exactly on that revenue side, right? It sounds like, based on what you're presenting, the revenue portion might be able to be addressed through an additional fee to get the multi-state license, even if not everyone elects to get one. But just acknowledging also then that, it doesn't necessarily affect the workforce side. And I think that's what, we're trying to kind of work through is, how can the compact be a piece in the workforce side? But it's not, it's not the solution entirely, but it's a potential help. So I don't know if
That's correct, Paige. So I think they put some assumptions in these sub bullets under potential revenue gains. And so that's working off of behaviors of other states that they have, that the cost of a multi-state license is greater than a cost of a single state license. And they're also making assumptions that people who are residents of Hawaii and have a license in another state that is part of the compact, they might say, oh, well, it's more cost efficient to have a Hawaii license that's $100 more expensive than pay for two licenses that are about $200 each, right? So there's cost savings to the individual, which is kind of the argument that they inferred at that meeting.
Got it. Okay, that makes sense. And I think then the question is that one of the things that might be helpful to understand, right? Because I think what we're trying to figure out, just in terms of just the fiscal impact, right, is, okay, there's this projected revenue loss and it affects RICO, it affects HSCN, it affects PVL. I think we, from the HAH side, we're also concerned about that, right? And I think there's some hope that using the compact could reduce some of the labor costs. I mean, I don't know what that looks like. It's not 1.2 million, right? That's not what you're gonna save. But it would be interesting to see if in other states, what percentage of licensed LPNs and RNs end up opting for a multi-state license, even if it costs a little more, right? And maybe that'll help us kind of figure out, okay, just on the fiscal side, right? Just on the fiscal side, do we have to worry about this as much, or does it have to be a larger fee? Could it be a smaller fee? Just going through this is very helpful data, I think, to understand just the fiscal side on that. And I'm curious how many would elect.
I can survey the National Forum of State Nursing Workforce Centers members, and also I'm sure that information is more readily available through Nicole and Robert, so we can ask that question for sure. And we will be inviting Nicole and Robert back to join us for our final meeting. I do want to recognize that we had Senator San Buenaventura join us, as well as Tom. I think he joined us again, so I just want to welcome your presence. And also, Eric, I see your hand is up.
Yes, thanks. Just a follow-up question. I know that the legislature enacted the licensure compact bill regarding physicians this past session. maybe the question is either to DCCA or to our legislators. Were these fiscal impacts an issue when the legislature enacted the licensure compact bill for physicians? And if so, what was some of the rationale? Would this legislation be cost neutral? Would it actually create burdens for physicians? And or whether it would be negligible? Thanks.
And then Linda also has a comment.
I'd like to add to that. This is Linda Beechnor from Hawaii American Nurses Association. That one of the concerns from our perspective is that the revenue loss and any makeup for that will come directly from fees that are paid by nurses who are licensed in this state. And if we lose 6,000 nurses who have a nurse licensure compact license and don't renew in Hawaii, then the burden is going to shift to the nurses who are licensed in Hawaii if we join the NLC.
No, and that's the reason why I asked the question, because similar legislation was enacted last year as it pertained to physicians, whether or not these issues were adequately addressed last year, and whether or not, from DCCA's perspective, are these costs negligible or substantial? Thanks.
Okay.
And I think, Laura, if I could just piggyback, and Linda, I think that's a really good point. And I think that's something we've wondered too. And I think that's why having more data on other states, right? My understanding is that what states can do is they can say, if you are a nurse and you would like to maintain a Hawaii only license, it would be the same cost. You're not compelled to get the multi-state license, but there is the option to get the multi-state license for, as a more premium product, I think is how the NCSBN or the NLC would look at it. You would pay an additional fee, right, to potentially cover the costs. And I think that that's a question, Linda, and I think this is what, we'd like to kind of talk about in this group is just, in other states, what are they seeing, right? Do a lot of folks then end up applying for that more expensive, but more portable, right, kind of more premium license? Again, this is words that NCSBN and NLC have said. I please don't ascribe them to me. But I think that would be interesting to know, right? And does it become a discouragement, right? What have we heard in other states? I think that's where I'm hoping maybe we can kind of figure some stuff out in other states that have implemented it.
So we will definitely go and seek that information. I don't know if anybody has that information on hand, but we have that written down. Just being considerate of time and knowing that we do have more meetings in the future, we'll address those questions. And then at this point in time, let's move the agenda on to Chelsea Fukunaga and Leanne Tashima of the Hawaii Board of Nursing. And I will share my screen. And then if you let me know when you would like to have slides forwarded, I am happy to do so.
Thank you, Laura. Can you hear me? It's Leanne.
You sound great.
Okay, so I just wanted to kind of touch on Eric's question. I'm not familiar with the legislation that went through for the Physicians Compact, but I know that the Physicians Compact is very, very different from the Nurse Compact. So you can't really compare the two. It's like apples and oranges. So there may have been some fiscal impact on the physician side, which I cannot confirm, but it is very different. I think, if I remember, the Physicians Compact allows them to charge a fee for an application. The Nurse Licensure Compact does not allow us to charge a fee for any person who holds a multi-state license who wants to practice in this state. So there is a big difference there. So I don't know what the fiscal impact, we can try to find out to see what the testimony presented to the legislature was. Okay, so moving on to my presentation or our presentation, I'm sorry. As far as the average number of licenses being issued, you have that in front of you, approximately 28 per month. This past count at the Board of Nursing meeting, it was over 1,000, 1,100 to be exact. That was for a 2-month period. So we're averaging anywhere from 400 plus to 500 plus RN licenses. Advanced practice registered nurses, approximately 37. Next slide, please. The current wait period. Okay, the current processing time is normally, if you look at our website, it is 45 to 60 business days. However, we have been processing applications, excuse me, between 20 to 36 working days. These times have been reduced from the 45 to 60 business days because we have up to 8 additional relief workers addressing the volume of nursing applications. These processing times will revert to the past time frame once the contract of the relief workers ends in October. Next slide, please. I am so sorry. Challenges to issuing licenses, application deficiencies. The applicant may have answered no to the prior conviction question. They may not have ordered their nurses verification instead of a quick confirm, which we don't accept. They may have indicated a prior disciplinary action, but not submitting the appropriate documents. Just a bunch of deficiencies there. They're just not following the instructions, which we're working on, by the way. So as for staffing, yes, again, we do have relief workers whose contract will end in October. So we are getting extra help, which, as you can see, is helping tremendously. So, but that'll end in October. Next slide, please. So in order to, in anticipation of us losing these additional relief workers, we have 2 initiatives. As you know, Senate Bill 63, which was the temporary license bill, died on the last day of the legislative session. What we are working on is to take that language and putting it in our administrative rules. We found that we probably could do that way. So not everything will be transferred, but the gist of it. So we will be amending our administrative rules. We are in the process of that to allow for the board to issue a temporary permit to a LPN or RN who is licensed in another state, unencumbered, wants to practice here. They just have to submit a temporary permit application. I think the fee is $100, and the current temporary was for 3 months. This temporary permit will be for 6 months. This will allow, if the temporary nurse would like to start the applications process at the same time. And I can tell you, a lot of them wait till the last minute for whatever reason. So not our fault, knowing the processing times. And that's why even under the emergency rules right now, these people decide at the last minute they want to stay, and then they are trying to hurry us up to process their applications. The temporary permit will also require a nurse's license verification and I think that's all, Chelsea, because the MPDB We're waiving
You're
that
correct.
requirement.
It does require the nurses, and then the facility will check for the NPD part, yeah, or the criminal background
Criminal
check,
background check.
because
Yeah,
NPDB is reported through nurses.
right. So we're just going to keep it very simple, the requirements. That obviously will shorten the processing time for those as well. The second initiative, we are almost done, hopefully. We're just testing now, is the digitizing of our applications. As you know, right now you can submit an application online, but it's not processed online. This one will allow us to process it online. It will allow an applicant to read the instructions, make sure they have their documents to be, quote, uploaded when they start the process, so that everything is submitted, including the fees and payments, so that the office assistant in our licensing branch can process it right then and there. So we're working on those two initiatives right now. Next slide, please. This is the purpose of the Board of Nursing. Based on their statutes, in order to safeguard life and health, any person practicing or offering to practice as an advanced practice registered nurse or a licensed practical nurse in this state for compensation shall be required to submit evidence that the person is qualified to so practice and shall be licensed as provided in this chapter. It shall be unlawful for any person not licensed to practice or offer to practice nursing as an APRN, RN, or LPN, or to use any sign, card, or device or any manner indicated, blah, 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 blah. Okay, so your Board of Nursing consists of volunteers, 2 public members, and 7 nurse members, including nursing educators in the state. They're volunteered, appointed by the governor's office to establish the minimum competency requirements for an individual who obtains a Hawaii license to practice safely in this state. I can tell you this board takes their job very seriously. They're not afraid to deny anyone who doesn't meet that minimum standard. So I'm just saying they are doing an excellent job, taking their job very seriously. Next slide, please. Okay, so, you know what? I think this is in line with the ULRs, the Uniform License Requirements of the NLC, which I think Chelsea prepared another slide. She added it at the end, probably. Can you go to the next slide? So yeah, these
so-
are all the are
Yeah,
these the
so you're just gonna
NLC?
address them. These
Oh.
are the NLCs, and then you just
Okay.
address them one by one. Yeah.
I'm sorry, can you go back then? Okay, so meets the requirements for licensure in the home state of residency. Okay. I don't know how to address that first one. I don't understand what that means. Number 2 so comparing Hawaii's current requirements with the uniform license requirements of the Nurse Licensure Compact. We'll go down the line for education purposes. Looking at their education for US educated or international educated individuals, our requirements are equivalent. If you are a graduate of a US accredited nursing program, you will qualify for a license. If you are an international graduate, you need your credentials reviewed to ensure that your education is comparable to someone educated in the United States. All applicants are required, if you're international educated, is not taught in English, then yes, you need to take an English proficiency. Next slide, please. We require all applicants for a Hawaii nurse license to take and pass the National Nurse Exam, which is the NCLEX, whether you're a RN or a PN. There is a state board test pool exam that was prior to the NCLEX. Some of the states use, including Hawaii. You rarely see those individuals who come in under that though. But so all applicants for a Hawaii nurse license must take and pass the NCLEX exam. Number 5 is eligible for or holds an active. Okay, so if an applicant applies for a license and they indicate that they have, and it's confirmed through their nurse's verification that they have an encumbered license in another state, obviously these people won't be able to, I don't think, qualify for a multi-state license. But so I'm not sure about this one, but for an encumbered license, the board looks at any applicant who has prior disciplinary action and or a encumbered license in another state. They will look at the basis for the disciplinary action, how long ago it was, and how it was directly related to the profession. In addition, if that violation was to occur in Hawaii, would Hawaii take, does Hawaii's laws and rules allow them to take action as well? For example, a nurse in another state failed to complete their continuing education and they got fined by a board. So that's disciplinary action, not necessarily encumbered. But when they apply here, they'll disclose that prior disciplinary action. And that's what the board will look at to say yes or no, whether they're going to issue the license or not. Number 6 has submitted to stated and federal fingerprint-based criminal background checks. The NLC requires the fingerprint for all multi-state licenses. Hawaii, this was added, I believe, in 2018 to our requirements. So we also require both state and federal fingerprint-based background checks. Number 7 has not been convicted or found guilty or has entered. Okay, so there is a question on the application. If you look at our application, it says, have you ever been convicted of a crime? It does not distinguish between a misdemeanor or a felony. A crime is a crime. Conviction is a conviction. And the reason we do this is, you know, a DUI, for example, can be a misdemeanor in another state, even in this state. But if you have several misdemeanors, like several DUIs, that is going to be a concern with the board, okay, or for the board. So we don't distinguish between a felony conviction or a misdemeanor conviction. And I believe, and they'll look at it also on a case-by-case basis. So we're almost similar to the NLC requirements on that one. Oh, what happened? Go back. Okay. Okay, go forward. Okay. As for this, number 9 is not currently a participant in an alternative program. My understanding of these alternative programs is if a nurse volunteers that they have an addiction problem, that they will enter into some kind of program, rehab program, and let the board know. That board, under their laws and rules, their authorization, can accept that by entering into some kind of an agreement with the nurse that as long as they participate and complete the alternative program, that it will not be considered disciplinary action. Hawaii does not have that. So we would have to add this to our requirements. Number 10 as well, because we don't require that. If most states, we can find it when they do a nurse's verification, it will have a list of all the nurse licenses they held or currently hold in any other state, as well as any disciplinary action. Some states, even though they don't consider it disciplinary action, they will list this as a possible disciplinary action, or the nurse themselves will self-disclose that they are in an agreement with another state in this alternative program. Valid social security number, US social security number. Yes, that is a requirement for both exam and endorsement applicants. Next, please. Can you, well, is that it? Okay, can you respond to the concern that board may take as it relates to? Okay, so I already mentioned this, directly related to the profession. So if the nurse applies, they answer yes to the question. Or even if they answer no, we want an explanation why you answered no. When we pulled your nurse's report and it indicated that you were, quote, disciplined in California for whatever reason. Directly related to the profession, that's what they'll look at, how long ago it was, and if they're in compliance with the terms and conditions of the sanctions imposed by the other board. If it's not clearly indicated, we will ask them to get a letter or some kind of document from the other board. Whether the license is encumbered, if it's on probation, what are the probation terms, they have to practice in that state. The board will consider that an encumbered license. Next, please.
That's the end of the slides.
Oh, that is?
Yeah.
Okay, I'm done. Okay, wait, so let me check my notes to see if there's anything else. I think that's, oh, for the geo report, I know the only one available right now is that September 2022, but we're checking with our IT person to see if we can get an updated one so we can get more accurate numbers. And that July numbers that you provided, that was right after the current renewal that just ended on June 30th. So yeah. Any questions? None?
So
Okay, thank you. What?
I want to provide a little bit of context, just in case the working group members weren't matching this up, and confirm with me that you're on the same page. So NCSBN reported that in addition or as part of the Model Act, Hawaii has to conform with 11 uniform licensing requirements. And so that's what Leanne and Chelsea prepared. I did have one question. I had two questions, Leanne, related to your review of those 11 uniform licensing requirements. One is related to, it was item 5, and let me go back to that. Oh, here, I'll share the screen again so we can all look at those requirements. So one is, so there's a requirement that we have passed an English proficiency examination for graduates of an international education program not taught in English, or if the English is not the individual's native language. So we do have that as part of our current state requirements.
Right, that's we base it out of the credentials evaluation that we receive from CGFNS. It does indicate if the nursing program in that country was taught in English or not. Yeah.
Great. Thank you for clarifying that. And then the second one, oh, did you have a question on that section?
I did. This is Linda Beechnor from Hawaii ANA. Actually, the URLR says that if English, I'm sorry, let me withdraw that. Thank you.
Okay, that was not a question. And then does anybody else have any questions for this first slide?
Oh, no. I have something to add.
Sure.
I'm not sure. When I looked through the uniform license requirements, there was, it mentioned a psych evaluation for a sex offense involving a minor or some other sex offenses. We do not currently require that, and we're not sure we can ask for a psych report for an applicant for a nurse license. So that's something, if it's going to be a requirement under the NLC, I'm not sure if we're going to be able to comply with that. The other ULR that I noticed is a, oh no, that was a substance use. Oh yeah, this is different from the alternative program. This is a self-disclosure of a substance use disorder. We don't currently require that specifically on our application. So unless it's a prior conviction or a prior disciplinary action, that's something we will also have to add. And again, check if it is in compliance with other state laws, including maybe the ADA, because this is really kind of confidential information. So I'm just saying, because this also applies to the renewal requirements. as well as for endorsement requirements. So those are the two things that kind of stuck out when I read through the uniform license requirements, as that's not something we currently do. And I'm not sure if that's something we can even ask for. So I'm going to have to check into that. And we cannot deviate from the requirements, as you all know. Okay, thank you.
And so that actually kind of brings me up to my second question. So as it relates to an encumbered license, and I don't know if this is a question for you or if this is a question for Rico, or maybe this is a question for NCSBN. So we can assign it to wherever. But my understanding is that an encumbered license in nurses is kind of how every state can tell if another nurse is eligible for nurse license compact or not, related to that one provision. So for our state, how are we engaging in nurses? Is it like a automatic data upload? Is it every 24 hours? Is it once a week?
Okay.
Is there a
Okay.
delay that would make our information
Right.
verifiable?
Okay. So good question, Laura. When we when I got the board in 2010 or so, soon after that, we started participating in nurses, meaning we entered into an agreement with NCSBN to provide them with our license data. And that's how they were able to come up with these figures and numbers to provide you with revenue information. So what we provide them, and it's in our statutes, is the license, the name, the license number of the individual who we issue a license to. That is done on a daily basis. So anything that's processed on a day-to-day basis is downloaded into nurses. We also provide disciplinary action. So other states also report disciplinary action to nurses. So you could add, so if Hawaii approved a settlement agreement or any board's final order, that is automatically reported to nurses. So the other states can also, and it'll say that this nurse holds a license in these states, and they will also get a quote alert as to, we just posted a disciplinary action for that individual. I want to also add that denials of applications are also posted to nurses. So if a license is denied, then the other boards will also get that as a quote disciplinary action. This is very important information because of the current Operation Nightingale that is going on throughout the various states regarding allegedly fraudulent transcripts being issued by a whole bunch of Florida nursing programs, which has been a nightmare because some of these people have already been licensed in other states. We're talking about anywhere from 5,000 to 7,000 nurses as a whole, affecting the nursing population, possibly providing unsafe healthcare. So we are trying to work on this as fast and as diligently as we possibly can to make sure we have processes in place for our licensing branch. They are to check the list as soon as they get an application and check their name against the list that was provided by the FBI and the Office of Inspector General. Prior to issuing the license, they double check that list as well. Okay, so we're trying to do as much as we can on our part to prevent these people from either taking the exam or obtaining a license through our state. Thanks. I just want to throw that out there.
And I have one other question and there may not be an answer to this because I think a lot of this legislation is newer, but as it relates to practice changes where there is legal scope of practice or legal practice in our state that is different in other states, a lot of these are kind of the hot topic issues on the national news. So abortion, gender affirming care are easy topics to reference. I think they're in common knowledge. How does the Board of Nursing consider for instance, legal scope of practice in our state as compared to maybe illegal or not prohibited scope of practice in another state when you are reviewing those cases? And would that impact the nurse license compact at all?
My understanding is that scope of practice is not addressed under the NLC, right? It's only license requirements. As for how it works, if you're a nurse in another state and you come to Hawaii to practice under your multi-state license, I'm under the assumption that you have to abide by our laws and rules. Now, if that is something that this particular nurse coming from a state that had maybe a more restrictive practice as an LPN or RN, that will definitely affect the practice here. They may not, because I think our Practice Act for LPNs, RNs, and especially APRNs allows them to do more compared to other states. Some other states still have a collaborative or collegial agreement for an APRN with a physician. Our APRNs are considered independent practitioners. So I think compared to other states, Hawaii's Nurse Practice Act is very advanced. And that is kind of scary for an individual coming from a more conservative state to come here and practice and says, hey, I can do this, I can do this, I can open a hydration clinic, I can open a medical spa, that kind of thing, which is probably not true, but I'm just using those as an example.
Sorry, can I just confirm though that the licensure that we're talking about specifically, it doesn't affect the APRNs, right? So
correct.
Just
This is not, yeah, it's only LPNs and RNs, the NLC. APRNs have their own compact.
Okay.
Do we have any other, I don't know, Chelsea, if you had any other information to present, or if that was in total everything that you had. I think it completes everything that's on the agenda, and I just wanted to make sure that we're not omitting any information.
No, I think Leanne did a great job. I just wanted to kind of add that the rule revisions that we're currently working on would address a lot of the issues that we have with the compact coming into the state. So it would give us a temporary permit that we could discipline. It would allow us to charge fees. And it would give this expedited processing time as well. So I just kind of wanted to add that in.
Good one. Yeah, thank you, Chelsea, for doing the slides, by the way. And that's a good point.
Thank you
Chelsea
for presenting. You did a great job.
Representative Bellotti, I see your hand up.
Thank you. I don't know if this is appropriate question at this time, but it's something that Leanne said that I'm curious about. Leanne, your comment that we don't currently collect information about substance use disorders or the psych evaluation.
Right.
Okay, so I understand how we currently don't do that, but say we went into the compact, are you saying that, I guess, are you saying that we couldn't do that? Like we would, you're saying that we'd have to do statutory changes to?
We would, yeah. Yes, you would. If we join the compact, we're gonna have to adopt all the requirements under the uniform license requirements, and those are included in there. But I'm still looking into how those two additions, if that is something that we can do under our state law, or constitution, or whatever it is. Because I was told that those things cannot be asked on our application for those reasons. So I'm gonna have to double check that.
Okay, and I guess the fact that we've seen this compact in other states means that while I understand that there might be some constitutional challenges, we might actually be able to overcome those.
Yep.
Right? I mean, we would just have to identify in the law where we need to overcome those challenges.
Yeah.
Because at the end of the day, if you can disconnect the self-disclosure of these instances, I mean, it's like the criminal background check. Some of this stuff would actually emerge in the criminal background check. Right? So it's not like we can't ask some of these things. or we're not getting some of that information already. It's a substance use disorder. That's probably the most concerning one.
Oh, and the psych evaluation.
Where is the psych evaluation?
I saw that under the ULR. It was under number. It was,
It's a psych evaluation for convicted sex offenders.
Yep. Yep.
Involving minors.
Yep.
So I feel like if we're gonna say that we need to do those, or we don't currently do those things, we have to really like hone down and see if there is a legislative fix for those things. Because actually, in fact, again, I think I mean, the fact that other states are adopting it must mean that there's a consumer protection piece behind it that overcomes any constitutional challenges of privacy. So it's not something that's blanket outright impossible to do, I guess. So maybe, and I don't know, Laura, maybe this goes to the question of what, this is an area that we'd have to further understand if we adopt, this creates a question that we have to follow up on.
Yeah.
But it's not that you guys can't do it, right, Leanne? If we directed you to do it, you could do it. But we'd have to direct you.
correct.
Okay, so
So
thank you.
If you order me to do it, I'll do it.
And not have to order it, it's by law, if the law requires it, right?
That's what I meant. Yes, sorry.
Yeah, so Rep. Bellotti, well, I have that noted, and then I do have an order. So Paige had her hand up, and then Linda had her hand up next. So do you have any more questions, Rep. Bellotti?
I don't think so. I'm just trying to pour over all the great information coming into this working group. So I'm a little bit overwhelmed, but I probably will have more questions later.
We have more meetings to come, so we have time for that. Paige?
I've just decided that I'm just going to tell everyone, well, Della told me to do it. And so now I have to. That's everything. But I was going to say, Laura, that, and Chair, that I had reached out to Robert and Nicole also, right? And then I want to bring that back to our members too about what they require, because I think, you know, Leanne, it's really good to look through it with such a fine tooth comb. But I did ask Robert and Nicole specifically about the psych eval and the substance use. So I didn't mean to overstep, Laura, but I did send them a quick note. So they probably will appreciate maybe hearing back a little more, because, you know, we do want to look through that. And then, you know, Leanne, I think from the employer side too, right, we want to make sure that we know what's required. So I did want to clarify. Thanks.
Thanks, Paige.
Yeah, thank you, Paige. Appreciate that. Linda?
Hi, Linda Beechner from Hawaii ANA. My question is, does the Board of Nursing have any concerns about the inability to know about individual nurses who are practicing in our state? Because it was very clear from the answers that we got from the NLC information that there is no allowance for knowing who is practicing in the state.
Yes, it's Leanne. Can I answer that question? Okay,
Please.
thanks. Okay, yeah, Linda, you're right. This has been from the beginning of all of this, that has been an issue for the board as well as for the Center for Nursing, who does the workforce study, right, for the state of Hawaii to see if we have a current nursing workforce or appropriate current nursing workforce. So not knowing who's actually practicing in the state was a concern, or is a concern for us, and including, segue to RICO, an enforcement issue. What prevents someone from coming into this state, practicing, maybe diverting drugs, and then just going back to where they came from. Now, unless an investigation can be done and enough evidence for RICO or the board to take action against this quote individual's multi-state license, as we heard from the NLC, it will only affect their ability to practice in this state and not So that would still allow them to go into the other states to practice as part of the compact. And it's up to those individual states to take action individually against that person's multi-state license. So yes, that is a concern. The other concern on that is it will be the requirement or the responsibility for the healthcare entities to make, Paige, cute, to ensure that the nurse, that they vetted that nurse, right? They went into nurses, they are registered and signed up with nurses, and that they vetted that nurse. They looked up Leanne Tashima and to see if she has a license in another state, or is it encumbered, anything like that. That is going to have to be also built in to any legislation. So now we have to bring DOH in because, hey, we have a requirement for your healthcare entities that they must comply with this. They must check and vet the nurse before they allow them to practice in their facility.
Yeah, and I think I can't raise my hand for some reason. So I think, Leanne, that's a really good point, and Linda, that's a good point too. But I think when I've talked to our members about it, I think there's openness to providing that information. I think especially understanding how useful it is for research purposes, especially, you know, Laura, I know that we rely a lot on your organization for a lot of research. So I do think there's openness to it, and you know, we can walk through it, but if that's somewhere that we can be helpful, you know, and potentially bringing in DOH and talking about that, I think, you know, we're willing to kind of find a solution there, because that is a legitimate piece that we want to try and solve.
Okay. Does that answer your question, Linda? No.
It does, but I think from my understanding of what the NLC was saying, that even if we do something with DOH in the facilities, that they prohibit individual names being supplied to the Board of Nursing of nurses who are in the state. They will only allow us to ask for demographic information.
If I may, Linda, the clarification is that the Board of Nursing can't require or ask any additional information that's what's in nurses. But if, for instance, and Paige made this example or reference Department of Health. So what other states have done is they've said, well, if we can't ask the Board of Nursing to ask nurses to report, then we can ask employers to ask their employee to report. And so it no longer becomes a Board of Nursing collaboration for data collection. It's an employer mechanism for data collection. And then your data collection kind of like approach or methodology changes, and also your collaborative partners changes. So right now and I just want to recognize who's in the group. We don't have the Department of Health on our working group. And so we need to apprise them of this conversation and also apprise them of what other states have done, so they could just, you know, give like justly review all of the information and then comment on that, so that they have that information at hand. But so it would not be a Board of Nursing requirement, and it would not be a substantive change to the nurse license compact, because what would happen and what other states have done is they put it into a different statute requiring a different department to follow up on a different kind of data collection.
Yep.
So it's not changing the nurse license compact. It's
Yep.
telling a different department, please help us collect the data that we've lost from this other, you know, we're kind of like, we can't do it here, but we can do it here. So it would be separate from the nurse license compact.
And I do understand that it's data related, not related to the individual nurse who is working.
So the employer could be asked to have their employees fill out a full nursing license survey. And that is separate and different from the nurse license compact.
And that
Yeah,
can be,
and maybe, you know, it sounds like a lot of this is related to kind of the data portion and research portion, which I think is, you know, again, I want to make sure that we're supporting. So maybe that's something that we can talk about a little bit more
We do have a
Get it
full
clear.
docket scheduled for a future meeting.
Perfect, yeah, that would be helpful, and then we can talk about it more too and see what, you know, I think we want to look at where we can make sure that there's support on that research side, because that is important.
Yeah, and just to clarify, we will be asking other boards of nursing, as you all have the sneak peek for meeting 4, we will be asking other boards of nursing to comment, and other states, not necessarily just the boards of nursing, to comment on how they address challenges that they have come across in the Nurse License Compact. And then we will also be asking members of the National Forum of State Nursing Workforce Centers, as well as the National Council of State Board of Nursing on their data, their nursing workforce research activities and how NLC has impacted that. So those will be upcoming meetings as well. Walden, I see that your hand is up.
Yeah, hi Laura. So just a quick question. I guess maybe this is for Leanne, but is the opinion of the board that, you know, until all of the requirements are met, you know, whether they include the psych eval or some of the information that you feel is not able to be asked either constitutionally or legally, is it kind of the opinion that it's not a possibility to even enter the compact, or entering the compact, maybe let's say, you know, if it happens next session without the other processes in place, makes it kind of null?
I'm not sure if you had a chance to look at our testimony this past legislative session. There were several issues the board has raised, you know, and understanding being part of an umbrella agency, we are not autonomous. So, you know, we can't make a decision. We have our own budget, and, you know, we'll be really adversely impacted fiscally by this. So we have to consider the department's position on the fiscal impact, as well as what the purpose of the board is, right? So for example, one of the issues was continuing competency. Hawaii has a continuing competency requirement. These multi-state license does not have a continuing competency, but it is going to be based on their own home state. So if their home state requires continuing education or some kind of continuing competency, then they would have to be in compliance with that. My last research showed about 5 states. I don't have them on hand which ones they are, and if they belong to the compact, that currently do not have any kind of continuing competency requirement. So if they are part of the compact and they don't require it, and these nurses come in and they don't have any, they've not taken any continuing education or other learning activity to ensure continuing competency, then we're concerned with that. So besides the fiscal, besides that, and the enforcement, it's the loss of autonomy. You know, yes, we can change our Practice Act, but if we were to change our requirements, that would be something we won't be able to do. You are driven by the language in the NLC, legislators, the board, anybody, God could not change your Practice Act in regards to the licensing requirements. Does that answer your question?
No, Leanne, that's really helpful. And I mean, we are pretty familiar with the board's testimony regarding, you know, the nursing compact. But I guess I'm just asking from a more general stance that, you know, until like right now, it sounds like there is a little bit of a hurdle, you know, in coming to the uniform kind of like standards, if you will. I apologize for not using the correct terminology. But, you know, I guess my question is just real more basic, right? That if we don't have these kind of baseline standards as put out by the compact, does it even make sense to, I guess, join the compact through legislation?
Okay, so I don't know if the board has an opinion on that. Okay, so if the recommendation is to join the compact, even from the board, we would have to amend our requirements for licensure to add those additional requirements. It has to be aligned to the compact or to the uniform license requirements. If we want to join, but we don't want to add those, that's not going to be an issue. We have to. We don't have a choice. We have to adopt the uniform license requirements. So whether the board has an opinion one way or the other, it's not about the uniform license requirements. It's about the understanding if we joined a compact, this is what we need to change in our requirements. That's
Okay,
just
no, thank you, Leanne.
sure.
All right, we've got 2 more minutes of this section. I don't know if anybody has. any
Really? Oh my
questions?
God.
Almost off the hook. Almost off the hook, Leanne. And then it's Rika's turn.
Yay, yay. Sorry, Esther. Sorry, Rena.
But Paige, I see your face popping up. Do you have another?
Yeah.
Paige, seriously? What?
Yeah, sorry. I just got a response. I'm sorry. I just got a response back from Nicole, and she said that the compact does not require a psych evaluation. In that, I think in the case of the assault against a minor in particular, that portion. I think that if an incident comes up in a state, right, and then the board where the person is licensed, I believe that they're subject to those laws. So that may have been maybe like a case example that kind of came up. And so that's kind of how it is today, right? I guess, you know, if you're licensed in one state, you're practicing here, you know, you're still subject to the original state's laws. And then I think for the substance use disorder, what they noted was that you have to, it's regarding that enrollment in an alternative to discipline program. So I think it's kind of baked into there. So it might have been an example of that particular requirement in the law. So it doesn't sound like they're necessarily requirements there. And I think just to kind of go back, right, you know, I think Walden's question is really helpful, is that there's sort of this interesting dichotomy where there's some things that we may need to pass, right, and change in order to meet the requirements of this, but then there's other things that maybe, you know, Hawaii is a little bit more advanced on that we can consider protecting. So I think it does kind of sound like it's a little bit of a two-sided coin to some extent, you know, where we might need to kind of make some changes to get up to the standards that other states have imposed, but we do want to maintain, I think, as Laura and Linda have talked about, some of the standards that we have too. So just kind of on that.
Sorry, Paige. So I was looking at the chart that was distributed to everyone. The NCSBN uniform license requirements, applicant's responsibility versus board responsibility. And it says on page 2, under additional public protection requirements, criminal background check, require psychological evaluation for all individuals convicted of a sexual offense involving a minor or performing a sexual act against the will of another person. This evaluation should be performed by a qualified expert approved by the board. If the evaluation identifies sexual behaviors of a predatory nature, of the Board of Nursing should deny licensure. So this is under board's responsibility.
Okay.
So
I see. So what are the two different columns? Because I don't know that
applicant's responsibility and board's responsibility. But now that I'm looking at it though, Paige, so we wouldn't, obviously they would be quote convicted of a crime, right?
Yeah.
And we would see that through their fingerprint results, hopefully, right? And so once we see that, the requirement that would be included should the board joins the compact would be, if you were convicted of a sexual offense that blah, 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 you will be required to obtain a psychological evaluation.
Got it.
So it's my mistake. It's not a psych eval right up front. It is only if it is determined somehow the applicant was convicted of some sexual crime.
Got it. Okay.
So
okay,
that makes sense.
I also, I think, misinterpreted a little bit incorrectly. So it sounds like, but that would require a change then on your end.
Just to insert about that in particular. Yeah.
Okay. Okay.
Thanks. That was a good one. Thanks for bringing that up.
Yeah, and thank you for reaching out to NCSBN in advance. I think that document in particular is pretty informative because it's like, you know, everything seems, there's 11 license requirements, uniform license requirements, and it seems like we are pretty aligned. And that's kind of like what you see, that's the duck, but then you have to go below the surface of the water and you see how much has to happen underneath. And that is the working document that is off of the NCSBN page. So that was guidance to the Board of Nursing. That's what that document is. So each of the boards of nursing guidance document. So being able to interpret that and understand practically what would need to happen in order to effectuate a working nurse license compact, you want it to work on top and below the surface of the
Yep.
water. So I think that is a good framework, and we can probably use that as a reference for future meetings as well. So with that, and thank you again, Paige, for that advanced communication. That was super helpful.
Yep.
And at this point in time, I'm going to pass over the mic to our colleagues at RICO. We're very happy to have you joining us and talk about what RICO is doing and kind of how it relates to any potential legislation for the nurse license compact. You should have sharing privileges for your screen, but if it's not working, let me know. Oh, you got it. It's working.
Hi, good morning, everyone. My name is Rena Chung. I'm from RICO. I'm one of the staff attorneys. So I'll take about 10 minutes to provide an overview of the actual laws and rules that provide legal authority to take disciplinary action against nurse licenses issued by the Hawaii Board of Nursing. How's my sound, by the way? Can everyone hear me?
You sound great. Thank you.
Okay, thank you. So, and then the last few minutes of my presentation will highlight those provisions of the compact that would authorize Hawaii to take disciplinary action against holders of the multi-state license who are operating under a practice to privilege nursing here if Hawaii were to join the compact. Then after my presentation, I'll hand you over to Esther Brown, RICO's Chief Enforcement Officer, and her presentation will cover in depth the licensure regulatory enforcement process in Hawaii, including the distinct roles of the licensing boards and RICO's operations, as well as some of the practical issues that arise in enforcement cases. So just to quickly cover, RICO's website does have a tab along the top here that provides links to the actual laws and administrative rules. Now, fair warning, it does link back to the legislature's website, and given the time of year that we're in, not all of the HRS sections on the legislative website have been updated to reflect amendments made during the 2023 session. However, there is an online resource that you can consult to look up whether a particular section of the HRS has been affected by this legislative session. And this is a publication from the Legislative Reference Bureau. I will be pasting the link to this publication in the meeting chat. Okay, so let's take a look at the main sources of authority for disciplinary action against nurse licensees in Hawaii. It would be Chapter 457 of the Hawaii Revised Statutes, of which Leanne covered some of it. The Hawaii Administrative Rules, Chapter 89, as well as Chapter 436B of the Hawaii Revised Statutes. And this is the Model Licensing Act that covers all of the professions and vocations that are regulated in the state. So looking a little more closely, these are the key statutory and administrative rule provisions that address disciplinary actions that may be taken against nurse licensees here. Many of you are very familiar with these provisions, so I'll just go through and highlight a few examples for the purpose of showing the range of conduct that is subject to disciplinary action in this state. So under HRS 457-12, you can see the board shall have the power to deny, revoke, limit, or suspend a license that was issued by the board and to fine or otherwise discipline a license for any cause authorized by law. And then the section goes on to give specific examples. So we have here examples of using fraud or deception in order to get a license, substance dependency, unprofessional conduct, repeat violations of the chapter, or as an example that was brought up earlier in this meeting, conviction of a criminal offense, and otherwise submitting a statement to the board or a document that is false or untrue. Let's look at what our administrative rules say about unprofessional conduct. Unprofessional conduct is nursing behavior that fails to conform to legal standards and accepted standards for the profession. And this conduct reflects adversely on the health and welfare of the public. So the admin rule gives a little more detail as to what constitutes unprofessional conduct in this state. So that could be, for example, under subsection 1, submitting false information regarding continuing competency requirements. It does happen, and RICO does see cases like this from time to time. Performing unsafe or acceptable patient care, failing to conform to professional standards, engaging in any act inconsistent with the practice of nursing. Okay. Now let's look at those disciplinary provisions that specifically apply to nurses who are practicing in Hawaii under a Hawaii license, including those who also hold a license in another state. HRS section 457-12, subsection A provides that in addition to any other actions authorized by law, the board shall have the power to deny, revoke, limit, or suspend any license to practice nursing as a registered nurse or a licensed practical nurse when the license is applied for or issued by the board in accordance with Chapter 457. The board shall also have the power to fine or impose some other form of discipline on a licensee for any cause authorized by law. So subsection A sets out 12 different examples that would give the board a basis for imposing discipline. And 2 examples are shown on this slide that would apply to nurses, excuse me, who are licensed both in Hawaii and in another state. Now, under subsection A, paragraph 8, the board can take adverse action against a nurse's Hawaii license if that nurse has a mainland license that has been revoked, suspended, or limited by the mainland state, or if the mainland state has taken other disciplinary action against the license. And then the next bullet point, you can see subsection A, paragraph 10, the board can take adverse action against a nurse's Hawaii license if the nurse failed to report within the 30-day time frame disciplinary action taken against that nurse in another jurisdiction. Oops, excuse me. The last item on this slide, HRS section 457-12.5 under subsection A provides that in addition to any other actions authorized by state law, the board shall have the power to deny, revoke, limit, or suspend any license to practice nursing as a RN or LPN when the license is applied for or issued by the board in accordance with Chapter 457. Oh, excuse me. Sorry, let me back up. Section 457-12.5 provides that if the board receives evidence that revocation, suspension, or other disciplinary action against the licensee occurred in another state, the board is authorized to issue an order imposing disciplinary action on the Hawaii licensee as long as the board complies with the following conditions. Number 1, the board must serve the licensee with a proposed order imposing disciplinary action. This is a requirement of Chapter 91, our Hawaii Administrative Procedure Act, and this is part of the due process that is afforded to the licensee. Number 2, the licensee will have the right to ask for a hearing to show cause as to why the disciplinary action being proposed should not be imposed. Number 3, any request for a hearing must be made in writing and filed with the board within 20 days. And number 4, if the licensee does not submit a request for hearing within the 20-day time period, the board must issue a final order imposing the disciplinary action described in the proposed order. So there is a process for this that does take into account due process protections when the board is considering imposing discipline based on action taken by another state against that licensee. So now let's look at provisions under the compact that would allow discipline against nurses. The compact does specifically contain provisions relating to disciplinary authority, jurisdiction in the privilege to practice state, as well as the applicability of state laws. So under Article 3 of the compact, and Article 3 relates to general provisions and jurisdiction, Article 3 subsection D does explicitly say that all party states shall be authorized to take adverse action against a nurse's multi-state licensure privilege. Okay, by doing any of the actions listed on this slide. Article 3 subsection E also states the practice of nursing in a party state under the multi-state licensure privilege will subject the nurse to the jurisdiction of the licensing board, the courts, and the laws of the party state where the client's located at the time the nursing services were provided. Article 5 of the compact addresses additional authorities invested in party state licensing boards. And Article 5A subsection A1 states, in addition to the other powers conferred by state law, a licensing board shall have the authority to take adverse action against the multi-state licensure privilege to practice within that party state. And then that subsection goes on to list the specifics of how this would work. And I want to highlight paragraph 6. If otherwise permitted by state law, the recovery from the affected nurse, the costs of investigation and dispositions of cases that result from any adverse action taken against that nurse. So the compact does have language that allows this, but I'd like to call attention to this very important phrase, if otherwise permitted by state law. So earlier in this meeting, we at several points discussed changes to Hawaii law that would need to be considered in order to make this system workable should Hawaii decide to join. And so I think it's important to point out that I don't believe Hawaii currently has a law explicitly allowing for this scenario. Excuse me. And this is my last slide. In paragraph 7 under Article 5 subsection A. Leanne, I think I caught whatever you have, even though we work in different offices. Okay, this section would allow adverse action based on the factual findings of the remote state, as long as the licensing board follows the procedures that it has in place for taking adverse action. Okay, so that is my presentation. And now I will turn you over to Esther Brown, who will speak with much more detail and can answer all of your questions.
Okay. Laura, can I have control because I have a PowerPoint also?
You should be able to.
Okay, let's see.
But if not, let me also I can make you co-host of the power. Oh, Amy, can you read? Oh, so sorry. We have too many computers going on. Okay, should have co-host.
Okay, let's share screen. Oh gosh.
Everything changes. Zoom changes everything every 3 days.
Can you see that?
It's not sharing, no.
Okay. How about now?
Yeah,
There we
so
go.
good.
There we go.
Yeah, it looks good now.
Okay, let's see. Now let's just make it play from the beginning. Okay, can you see that?
Great.
Okay. Okay. Hi, everyone. I'm Esther Brown. I'm the Complaints and Enforcement Officer for RICO. Thanks so much, Rena, for that introduction to the laws and rules that apply to nurses. I'm just going to speak for a few minutes about the basics of the enforcement process and how RICO and the PVL boards interact. And then I'm just going to touch upon quickly 2 issues related to the NLC, and that is procedural due process and the funding mechanism. So we are the Regulated Industries Complaints Office, or RICO. And so the question to be asked is, what exactly is a regulated industry? And that is an industry that is regulated by the state because policymakers have determined that the services provided to consumers in the industry impacts their health, safety, and or welfare. The next question to be asked is, what exactly is enforcement? Because that's a term we've been throwing around a lot and we will be going into these meetings. So what are we talking about when we talk about RICO and PVL enforcing the law? We're talking about the process of imposing consequences for proven acts of misconduct by a licensee in a regulated industry. So it's imposing consequences for proven, not alleged, proven acts of misconduct by a licensee in the regulated industry. And how is the enforcement process organized here in Hawaii? There are 2 parts to it. The first is DCCA's PVL division has 52 boards, commissions, and programs that oversee practitioners in a regulated industry through the licensure process. RICO partners with the PVL to regulate misbehaving licensees. So let's look at the licensing boards. There are 3 steps to the enforcement process. First, you have to establish standards for licensure, and then you issue and renew the licenses. That's step 1, and that is performed by PVL and the licensing boards. Let's jump over step 2 to step 3. At the end of the enforcement process, it is the licensing board that has the authority to encumber a license for misconduct, meaning, as Rena said earlier, they can condition the license, impose a fine, or even suspend or revoke the license. RICO acts at step 2. We're in the middle of the process, and we perform functions that have been delegated to us by the licensing boards. One thing I'd like to note is that step 1, which is the issuance and renewal of licenses, this is the place where the majority of licensees will interact with the board. And many will not go to step 2, which is great because you don't want to be on RICO's radar or be investigated for potential misconduct. So I'm happy to say that the majority of all licensees across the board interact with their boards at the step 1 level only. Now, RICO does step 2, and there are 3 characteristics of RICO. First and foremost, we are an independent agency. Secondly, we are an umbrella enforcement agency, and that's a term that Leanne used earlier in her presentation. And finally, our work product is confidential, okay? And again, we are the middle person in the enforcement process. So let's look at each of these characteristics briefly. Okay, RICO is an independent agency. What that means is RICO is not an extension of the licensing boards. This is the most obvious and significant characteristic of RICO being independent. There's also a key advantage to RICO's distance from the licensing boards, and that is because we are not a part of the licensing board. We insulate board members and their staff from temptations and accusations of bias, prejudice, vindictiveness, or partiality in pursuing or prosecuting charges against their peers, their colleagues, and their competitors. Because, as we know, and as Leanne said earlier, the majority of the board members are licensees and industry practitioners. So by having a different agency perform these prosecutorial functions, you insulate those board members from any allegations of being tainted in the disciplinary process. Another advantage to RICO being an independent enforcement agency is that it ensures that integrity is built into the process through objective reviews, investigations, and legal assessments. In other words, RICO is not beholden to the individual preferences of board members or the public or even the media. Respondents or licensees who are under investigation, they want and deserve an objective investigation, and due process demands it. And finally, because we are our own agency, Our review process is very thorough, and we have multiple levels of review for almost every case out there, meaning more than one investigator will touch it and look at it, and more than one attorney will also look at it. So that ensures the objectivity that's needed for good investigations. From a practical perspective, RICO is an independent agency because we have our own funding, separate and apart from the Board of Nursing, and we are funded primarily by licensing fees. We have a large staff, and we have offices that are statewide. Our main office is on Oahu, but we also have offices on Kauai, Maui, and 2 on the Big Island. We have a total of 67 full-time employees currently working for RICO. And finally, our work is insulated, meaning much of what we do is confidential and remains in-house. And this is very, very important. And this is based on state law that basically says practitioners have a significant privacy interest in evaluations of their fitness to practice. And I think many of you on this call who are professionals definitely, don't want your stuff aired out unless there is cause and the allegations can be proven. So much of what we do is protected, confidential, remains in-house. With respect to the healthcare industries, almost all complaints that we receive will involve a patient or patient care or patient treatment. And as you know, patients have a heightened expectation of privacy in their medical and healthcare information. RICO is also, one of our characteristics is that we are an umbrella enforcement agency. That means we are responsible for enforcing the law for all 52 boards, commissions, and programs, inclusive of the Board of Nursing. That means under our umbrella, we have 4,000 plus licensing statutes and rules that we need to be familiar with. That means the agency is really busy. We get approximately 2,500 new matters and new complaints that are processed each year. Our work product is confidential. I alluded to this earlier. That means there is limited data sharing with the boards, including the Board of Nursing. The Board of Nursing provides information to RICO, and Leanne talked about this a little bit earlier. It's a one-way street, and RICO receives from the board critical directory information as well as substantive information when a complaint is received and investigated. What is the critical information? We receive information about the license, the tangible thing that we may have to take action against. That includes the license number, the issue date, and the status of the license. We also get holder information. Who is affiliated with that license? What is their address? And what is updated contact information? And finally, we get any information or records from the licensee that was provided to the Board of Nursing and any information that was provided to the Board of Nursing by another state. The data flow from RICO to the Board of Nursing is not as broad as that. In fact, it's very limited. It's a one-way street, and the information that's provided is publicly filed information only. And this is information that is provided through the administrative hearings process and or via board meetings. And what type of information is this? Well, Rena talked about it a little bit earlier when she was talking about Act 38 reciprocal discipline. And that is the petitions for disciplinary action. Here is the official document that would lay out the charges of misconduct that RICO will be claiming it can prove in a prosecution. It includes any notices and interim orders that are filed by the hearing officers. It includes any evidence that's entered into the record when we go through the hearings process. It includes any filed settlements and board final orders. And it also includes any post-board final order filings. This is fair game. It is public, it goes to the board, and any public member can receive the information as well. And then finally, again, RICO is the middle person between issuance and forceful encumbrances of a license. We perform the investigative and prosecutorial functions only. The process that we perform this is the same for all 52 boards. It starts with us receiving inquiries and complaints. We review it and investigate for possible licensing law violations, and then we settle or prosecute them administratively. I'd like to give you just a snapshot of the Board of Nursing workload for RICO. According to my staff, in the last 5 fiscal years, we processed 1,514 nursing matters or complaints. That would average about 302 a year. A very small percentage of this number results in formal discipline every year. I would say less than 10%. Nevertheless, substantial resources are used daily by RICO staff to vet, investigate, and bring cases to conclusion, regardless of whether discipline results. I'd now like to talk a little bit about practical enforcement considerations related to the NLC, and in particular, jurisdictional conduct, which Rena covered in depth, thank you, procedural due process or notice and opportunity to be heard, and the funding mechanism in the NLC. With regard to jurisdictional conduct, the question to be asked is, what makes a person fall within RICO and Board of Nursing's enforcement jurisdiction? Easy. They hold a license that was issued by the Board of Nursing, whether they're in state or out. If they hold a license that came from the board, then they are engaging in jurisdictional conduct. Secondly, if they perform work in the state that requires licensure, they are engaging in jurisdictional conduct. Under the NLC, jurisdictional conduct is quite straightforward. If they hold a valid multi-state license in a compact state, then they hold the privilege to practice in any other compact member state. In other words, the Board of Nursing need do nothing under the NLC. The conclusion we reach is that exerting jurisdiction over nurses is not a problem now for RICO, and we anticipate few problems with the NLC since jurisdictional conduct is automatic under that. I would now like to talk to notice and opportunity to be heard, otherwise known as procedural due process. Basically, there are due process requirements that we as enforcement agency have to meet in order to sustain an investigation and prosecution. We need to have the correct person that we're going against. We need to have the correct license. We need to be able to communicate charges to the license holder so that they have an opportunity to be heard or respond. And we need to be able to serve the license holder with formal legal proceedings so they have an opportunity to be heard and to respond. Therefore, in order to get our investigations off the ground and to make sure that they are sustained in the end, we need the correct license holder, we need the correct license number and status, we need current and correct contact information, such as an address, a phone number, and an email. And currently, the Board of Nursing obtains this critical directory information from licensees through the registration process, and that information is furnished to RICO when we investigate a complaint. So what happens when we don't have this information? What are some of the unintended consequences? Well, let me share a realistic example that happened in 2022 right here in our state that many of you may be familiar with. And that is in March of 2022, the former Governor Ige's final emergency proclamation for COVID-19 came to an end, and that ended the licensure waiver for non-resident healthcare workers in Hawaii. This means potentially thousands of healthcare workers, including nurses, were present and potentially practicing in the state without a Hawaii nursing license. I remember we talked earlier about what is jurisdictional conduct that gets RICO's attention. Well, RICO was alerted because anyone performing work for which a professional license is required is engaging in jurisdictional conduct. So RICO got involved. Under the emergency proclamation during the COVID-19 pandemic, facilities, however, were only required to maintain a registration form that listed the out-of-state practitioner's legal name, their profession, and the entity that they were working for. And believe me, we're good with that because we were dealing with a healthcare crisis that we'd never seen before. And so we're very, very, very thankful for the many healthcare workers that did come in the state to help us navigate through that. So this is an example for you of the form that was actually provided to healthcare facilities so that they could register people, the traveling people that came into our state to help us. However, the Board of Nursing and other licensing board did not have any representations from the out-of-state practitioners about what their legal, proper, and former names are. They did not have any information about their home state license information, and they did not have any address or contact information. As a result of that, RICO staff expended 1,250 hours to the exclusion of other work, just trying to do the basics of procedural due process to determine whether unlicensed activity was occurring in the state, and if so, who was doing it. During this time period, they tried to correctly identify the people involved. They tried to correctly identify the licenses that were involved, whether out of state or in state. They tried to communicate potential charges to potential unlicensed holders. And we needed information to eventually serve if we had enough to institute a legal proceeding. The result of the 1,250 hours of work is a lot of inefficiency, and the unlicensed activity investigation stalled. The good news is that we learn as we move forward. And so when the emergency rules were enacted in late April of 2023 by the Board of Nursing, the registration form for healthcare facilities required key information and other important representations. And I'm going to show you the form here. So this is the form that facilities required to fill out. And if you notice, it asks for the name, where they hold the license, their license number, their residential address, their email address. And in addition, there are certain representations that are made not by the licensee, but by the person who signs this form, that they have done sufficient due diligence to assure the Board of Nursing that this is a good licensee. I would just like to acknowledge that employers play a vital and important role in addressing the nursing shortage, for which we are truly grateful. But at the same time, employers have their own employment, healthcare, safety, and other laws and rules and concerns to worry about. In other words, they're not licensed regulators, nor experts in the area, just as RICO and PVL are not employers, and we don't know all the ins and outs of being an employer in the healthcare industry. So the query is this: outside of an emergency proclamation period or an emergency rule period, will regulators be able to confirm that they have the correct person and reach that person swiftly for enforcement purposes when the NLC does not require non-resident practitioners to furnish directory information to the Board of Nursing? I think that's a very important question that we, RICO, ask ourselves constantly when we're looking at the NLC. The conclusion to be reached is that the absence of language in the NLC that requires non-resident PTP nurses to register or provide identification and contact information to the local Board of Nursing upon entry into the state will hamper regulators' ability to meet basic due process requirements to accurately and swiftly identify a party and notify them of charges so that they can be heard. And we know this because we lived it in 2022. The final thing I'd like to comment on is the funding source, registration fees versus cost recovery, as stated in the Nurse License Compact. Under Hawaii law, RICO operations are funded primarily by license fees that are paid upfront and at renewal, and by fines and judgments that we collect. Under the NLC, as Rena stated, and others, there's no license or registration fees imposed for non-residents who come here on a PTP. The NLC does, however, have a recovery and recruitment provision, which Rena went over earlier. It basically states, as if otherwise permitted by state law, regulators can recover from the affected nurse the cost of investigations and disposition of cases resulting from any adverse action taken against that nurse. So if we look at that a little bit closer, we will see, as Rita indicated, I and she are not aware of a legal provision allowing investigative and disposition of case costs recovery for Hawaii regulatory agencies. If it exists now or in the future, it will take time to develop sound guidelines and standards to quantify the type of cost that can be recovered to a reasonable degree of certainty. Also, the cost recovery provision is narrow in that it only applies to adverse action cases. And that's important because the vast majority of complaints do not result in adverse action. Most enforcement work occurs pre-adverse action. Also, cost recovery typically do not include attorney time and fees. That's a totally separate category. But in the enforcement process, RICO attorneys spend a lot of time and they are key to prosecuting adverse action. So arguably we would not be able to recover for that expense. The nurse, him or herself, also can have a significant impact on recovery costs too. They can dispute it, and that can lead to collateral or extended litigation. They can appeal the adverse action and any cost award, and that could delay payment pending resolution of the appeal. If we get a cost award, the nurse, who's probably out of state, may choose not to pay it or could be insolvent. If a solvent nurse chooses not to pay a cost award, then legal collections work would be needed to get at the money. And collections work is very resource intense. We would have to locate the person or the debtor. We'd have to do an asset search in the person's name, try to find property or bank accounts or employers to potentially garnish wages. And then we would possibly have to initiate legal collection proceedings in a foreign state, because that's probably where the nurse would be to enforce against an asset. The conclusion is that although the nurse license compact has language permitting cost recovery, for the reasons just stated, cost recovery at the back end is really a less favorable option to Hawaii's current practice of funding enforcement through licensure fees paid up front. And so I'd just like to summarize. RICO and the PVL boards co-partner in enforcement regulation. The PVL boards perform steps 1 and 3. RICO performs step 2. The NLC does not appear to be a roadblock to RICO's ability to exercise jurisdiction over practitioners working in an NLC member state pursuant to a privileged practice. The absence of a direct registration requirement with the Board of Nursing, however, and the absence of fees received by regulators upfront could hamper efficient and effective enforcement by RICO against misbehaving nurses. And that's the end. But I did want to address a couple of things from speakers earlier. I think it was Eric Abe who asked about the Interstate Medical Licensure Compact. And it's my understanding that that compact does have a registration or application requirement with the Hawaii Medical Board, and they do charge a registration fee. And the other thing is, Leanne and Chelsea, thanks so much for all the work that you guys are doing to incorporate the provisions of the DED SB 63 into the administrative rules so that there is some sort of a band-aid in between in the temporary licensure process. And that's it. Thank you so much, everyone.
Esther and Marina, thank you so much. I think that was wildly informative from my viewpoint or vantage point. I certainly learned a lot, and I think it clarified a lot of questions around that discipline process, not just related to the NLC, but also in general. We do have a couple minutes before we close our meeting today. Does anybody have any questions for our RICO colleagues who are present? I see Rep. Bellotti.
I have a question about kind of historical data on how much we've collected on fines where there's been involvement of nurses. Because Esther, I saw in your slide presentation deck, we do in fact collect fines or something from.
We do, yes, you are correct. Representative Bellotti, I can try to find that information. I'd have to go back to my staff. So let me make sure I understand what it is. You want to know how much in fines we have been collecting from nurses? And do you want to go back a time period?
Maybe 5 years.
Okay. Yeah, we can do that.
Well, and maybe 5 years before the pandemic. Right, because I mean, one of the concerns I'm hearing is like cost benefit, right? Well, if you currently are able to collect funds that offset, we should know. And then on the flip side of that, for Well, I'm just trying to, I'm wondering about collections experiences of current compact states
Mm,
in their own jurisdictions under whatever kind of cost recovery schemes they may have. So I hear you that it might be difficult to implement, but if that's actually a practice of regulatory agencies across the nation where we're getting cost recovery, we should not foreclose that.
and I agree, Rep. That would be very helpful to know how other states are doing it, really.
And then something else in your presentation, Esther. I understand how it's difficult to get that information about names and knowing when there's an out-of-state person practicing, but isn't the fix exactly what you identified? That we would have to ask the employers to give us that information, and if the employers are agreeable to that, then that takes out one of those obstacles, right?
I think that's kind of moving in the right direction for sure, Representative. I mean, I think, like I said, we're not employer experts, so we really don't know all the nuances involved in that. And also, I would certainly hope that if that is the way we go, that it's efficient, because right now we get stuff just like that. Hey, this happened at Queen's Hospital. This is the name of the nurse. Boom, we're up. We got it. We're contacting that person immediately. So speed is an issue. So if we can address that, that would work really well for us.
Paige was next and then Leanne.
Yeah, thank you. And Esther, I think your point about efficiency is well taken, and I think we can include that in our discussion. I think one of the questions I had was, just going off of the idea of being able to, essentially be able to recover the costs. If there was an increased fee for the multi-state license, right, to increase revenue, could some of that revenue go towards RICO and covering RICO's costs?
Paige, we automatically get a percentage of whatever fee, CRF fee, so that comes to RICO. We get it at the front end. So I'm imagining, if there is a $100 fee or what have you, RICO would have a percentage of that, and that does help, actually.
Okay, that's helpful. Thank you.
And then
Sorry, time's up. Okay.
all right, talk to you later. No, you're welcome to ask the question if you still want.
Well, I just wanted to touch on basically what I heard from Esther and Rena's presentation and what Representative Bellotti questioned, and it all appears to be the responsibility of the employer to report. We have no jurisdiction under the Board of Nursing to require, put in our laws, that Queens or Kaiser or any other healthcare entity has to report any disciplinary action they take against their employees. We don't have that jurisdiction over them. Only the Department of Health does. So I think we have to also look at that aspect of joining, whether everybody wants to join except for the Board of Nursing, but if everybody is moving towards that, we have to have a conversation with the Department of Health. They have to understand that under their licensing requirements for these healthcare entities, their statutes are going to have to change as well.
And I think to add to that, Leanne, if I can indulge for just another minute, under the form, the registration forms that employers have to fill out under the current nursing emergency rules, the last part of it basically makes the person who fills out that form for the employer responsible. Mm-hmm. It's the person who signs that form. So if a nurse misrepresents or gives false information and rationalizes away bad information in nurses, and the employer believes it and signs off on that form, they're responsible. But RICO and the Board of Nursing has no jurisdiction over that person.
Yep.
So I don't know who would enforce that. Maybe the Attorney General's office. I really don't know. But Leanne's point should be well taken, which is right now, The nurse fills out the form. The nurse signs the form. The nurse certifies to the accuracy of the information in the form, so that if it is discovered that there are misrepresentations, we go directly against the nurse. There's no intermediary in between. So I just wanted to add that to what Leanne was expressing.
So Esther's referencing the application for license, I'm assuming, because the emergency rules form that she showed to everyone is signed by someone from the healthcare entity, not the individual nurse. So yes, when the individual applies for a nurse license, they're attesting that all that information that they provided is true and correct. And we do a nurse's verification to confirm most of that information. So there is a way of us, you know, we have that information to track that person down if we need to. Whereas under the NLC, we will not have that information necessarily. We can probably check nurses, but if they provided incorrect information, or if for whatever reason they're not listed in nurses and the healthcare entity for some reason did not vet that nurse by checking nurses, then what do we do?
Can I ask two questions? And I know we're over time, but under the amended rules, Leanne, what is the system, right? So now there's this form that's being used under the emergency rules that requires the facilities, someone at a facility or an organization to attest to the information. Under the updated rules, what is that going to look like?
It's going to be submitted by the individual nurse, not the healthcare entity.
And maybe what we can do is also ask the NCL folks whether or not, you know, language essentially saying that an employer could require a nurse to submit an attestation form. Maybe that's one of the ways to look at it. Right? I know we're over time.
Yeah, you know what? We'll talk about this later. This is not. Hey, Chelsea, can I just clarify something with you though? When I just answered Paige's question, my understanding of the current proposed amendments to the rules for the temporary license will not require a signature or authorization from a healthcare entity. Is that right?
I thought it, I have to relook at it. I don't want to give a wrong answer.
Yeah, see, so Paige, I got to get back to you on that one and to the group. I don't believe we're tying it. We're requiring the healthcare entity to vet that nurse at this point. It's up to the nurse who applies. But I have to double check that. I might be wrong because I know we tried to mirror on the language close to Senate Bill 63 as well as the current emergency rules, so which requires the facility sign off on it. So I'm getting all confused.
Yeah, yeah, there's a lot of stuff out there.
Question, NCSBN in their responses to our questions, they did give a response on which states have required employers to collect information about the nurses that they're hiring under a nurse license compact. That information is already available. Yeah. All right. So we will see you all in 2 weeks. We'll be collecting. We're working on composing an agenda that includes having people who have researched nurse portability under the nurse license compact. So how many nurses may or may not come in or out of the state under nurse license compact. And we're also going to be asking other states about their experience with the nurse license compact, how they've addressed issues in implementation in their state for various reasons. So we hope to have a very full and robust agenda for you. And thank you so much for your time today. Aloha, everyone.